the case of Long v. Utah State Bar. I think you're both familiar with how we conduct oral argument. So let's begin with your appearances.
Emily Adams for the petitioner, Jennifer Long.
Welcome,
and Emily
Ms.
Lee.
Adams.
Oh, I'm sorry. Emily Lee for the Utah State Bar.
To have you with us as well, Ms. Lee. Okay, let's begin.
Good morning, Your Honors. Ms. Long showed clear and convincing evidence of good cause when she did not receive, and in some cases was denied, accommodations when she took the bar 6 times 20 years ago. And when her 5th accommodated attempt in 2024 put her within 5 points of passing. Now, good cause is a highly fact-dependent inquiry, and because it is situation-specific, ruling in Ms. Long's favor will not open the floodgates for other individuals to seek accommodations for the bar. When this court is considering good cause, it should give less...
Sorry to interrupt.
Oh, no worries.
Why would that be the case? Why couldn't we expect more applications like this?
Because it is a highly fact-dependent inquiry, Your Honor. And I think when you look at, Ms. Long has had documented disabilities from the very, very beginning. And she sought accommodations in Utah and then sought them once in Missouri. So she has a history of seeking accommodations and having documented disabilities. It would be very different, and I think one thing the bar is concerned about is if somebody fails the bar 6 times, goes and gets some sort of diagnosis, and then seeks to take the bar with an accommodation based on that diagnosis.
Yeah, they might lose.
Right.
But why wouldn't they be encouraged, if we were to waive the rule in this case, to at least try?
Well, of course they could try, Your Honor, but I think if Your Honor were to craft a decision that was very fact-specific and hinging on this good cause standard, which depends on the situation, and you could say, Ms. Long has had documented disabilities this entire time. This isn't a disability that she has come up with or has been diagnosed after not passing the bar 6 times. She was born without a right hand, and she was diagnosed with ADHD in high school. And she tried to get accommodations for the LSAT, which she had documentation of ADHD and was unable to get accommodations for that. She had accommodations throughout law school and her undergrad. So she's had accommodations throughout.
So you suggest that if someone got a more recent diagnosis, it'd be a different case, and certainly it would factually.
It would be a different case.
Why would we assign that as important if they have a legitimate diagnosis?
Yes, it would be different factually, Your Honor. And I think it goes to this inquiry. For example, if somebody knew during their exams, while they were taking these 6 attempts, that there was something that was impeding their ability to do well on the exam, and they failed to go seek treatment or to go find a solution, I think that certainly would play into the testing, the accommodations committee, the testing commissions, I'm forgetting the name of it, the bar's decision in whether there was good cause to seek a attempt beyond 6 times. So it will all go into analysis.
Sorry, can you clarify something in the record for me? My understanding, although when I was reviewing this again last night, I wasn't sure exactly where this came from, is that the earlier accommodation requests related just to the ADHD, not to the physical disability. Is that correct?
That's what it seems like, Your Honor. The record is a little unclear on that. So we do not have the accommodation requests for the Utah exams back in 2004 and 2005. We do have some of the documentation for Kansas in 2007 and 2008, and we also do have the accommodation request for Missouri in 2007. In Missouri in 2007, she asked just for ADHD. And in Kansas in July of 2007, it's a little unclear. She did mention that she only had fingers on one hand and that she had ADHD. That's on page 269 of the record. But in February of 2008 in Kansas, she asked for accommodations for ADHD. That's on record 387.
And there was an actual, didn't she actually state that she didn't need any accommodations for the physical disability because she had learned to function perfectly well with one hand? Am I remembering that correctly?
Yes, Your Honor. So she made that statement back when she was applying for accommodations in Missouri and in Kansas in 2007 and 2008. This was a person who was 20 years old. She was in her 20s and had frankly been quite upset her entire life that she had been born without a hand and was really determined to live life in a way where it didn't appear that she needed a second hand. And so she really believed that she could do it without one hand, without accommodations for that. But as she's learned, as she's gotten older, that she did need more time to write and to type when you only have 5 fingers on your left hand. And in fact, that's the difference in the accommodation requests between the Kansas tests in 2007 and 2008 and the Utah tests in 2003, 2023, and 2024. The Kansas accommodations were time and a half and a separate room, which is pretty standard for ADHD. The Utah accommodations were double time, so a bit more time, a break every hour, and in one test it was a 5-minute break, in another test it was a 10-minute break, and a separate room. So the Utah tests have given her additional time to accommodate the fact that she's only working with one hand, and also breaks because that one hand can get fatigued quite quickly.
And so those requests, so at the time that she applied to take the two exams ago, what was the year? Was that 2020?
In the 2007, 2008 in Kansas?
No, I'm sorry, the most recent Utah test.
Oh, the 2023, 2024.
Thank you.
Utah exams.
I even have the chart right here that you provided, which was very helpful, by the way. I should just look at it.
You should tell all of your clerks to make charts.
It's lovely. So the July 2023, she received exactly the requests that were, the accommodations that were requested, and the same in 2024, is that right?
Yes.
So how do we take that into account? I mean, I'm conscious of the fact that this isn't actually a situation where we're being asked to waive the rule. This isn't a situation where there's a firm rule that the bar doesn't have the ability to waive, and we're being asked to waive it in the first instance. We actually have given the admissions committee discretion to waive the rule, and so we're reviewing it. We're reviewing that under a standard of review that we've said has to be unfair or unreasonable or arbitrary. How do we factor in, or should we, the fact that the admissions committee already granted those 2 exceptions in 2023 and 2024 with the accommodation she asked for, in determining whether this 3rd request with additional accommodations, whether the denial of that really was unfair, unreasonable, or arbitrary?
Your Honor, the rules allow for 6 attempts, and as we've argued in the brief, it should be 6 accommodated attempts in this case, especially when the first 6 attempts were not accommodated at all. So when we're looking at, the 2023 and 2024, those were her 4th and 5th accommodated attempt. And in 2023, in the 2023 exam, she handwrote the exam, and she did fine. And in the 2024 exam, she failed, of course, but the 2024 exam, she handwrote the exam again, but it's in the record that she had extreme pain in her hand that then caused some significant problems while she was finishing her test. That was her first indication that there were any problems with this type of accommodation, that this accommodation was not going to work for her disability. So, Your Honor, I think that when you're looking at her circumstances specifically and looking at whether good cause exists here, you have to look at, she accommodated what she requested the accommodation she thought she needed, which was handwriting the exam and double time and breaks. But when that accommodation didn't work, she asked for that accommodation to be taken away. Given the fact that she's only had a test accommodated 5 times, the testings commission, or the bar, should have allowed her a 6th attempt to find an accommodation that would work for her. The rules allow individuals to take the bar up to 6 times, which means the rules allow for some kind of trial and error. If you are a completely able-bodied person and you fail the bar, there's going to be some trial and error as you're figuring out how to study and what you need to do to pass the bar. We should be given that same kind of grace to individuals who have disabilities. If they are seeking accommodations and that accommodation doesn't work, or in Ms. Long's case, something occurs during the test that has never happened before, the good cause standard should allow her to seek slightly different accommodations to take the test again.
Can you explain to me, so I understand that the accommodations for the ADHD were appropriate, is that right?
Yes, Your Honor.
And I apologize if I'm just being obtuse here, but how does the physical disability connect with the new accommodation that's being requested? I'm just trying to think that why would being born with one hand require anything different in terms of handwriting the exam? I mean, we all presumably write with one hand. And I apologize if that's an insensitive question or an obtuse question, but can you connect that for me?
Right. So she's missing the fingers on her right hand, so she has to write with her left hand, and there's some indication that it's just her brain does not want her to write with the left hand. It's very hard, and if you actually notice her handwriting in the record, it's pretty rough. And so it's harder to write with her left hand. Her left hand is actually, she started having carpal tunnel issues, and this isn't in the record, so please stop me if you don't want me to go on. But she has had carpal tunnel issues in her hand and had surgery in 2018 on that left hand. And so one reason that the February 2024 exam was so challenging was because she was really concerned that if it began to hurt, and the record says that her fingers started going numb, she was concerned that she could potentially lose function in her left hand. If she loses function in her left hand, she has no hands. And so it requires a bit more, because it is she's in her 40s now, and all of us know that when your bodies work differently in your 40s than they are in their 20s. And so it's just less able than it was before.
I appreciate that. Then thank you for that explanation. But it does heighten my concern about the standard of review here, if those facts were not before the admissions committee.
So before the admissions committee did have the information about the cramping that occurred in the 2024 exam, and also information that after that cramp, that it had not happened before in the 2023 exam, and that she immediately went and saw a physician and had a consult with a specialist so that she could figure out what she needed to do to ensure that cramping didn't happen again.
But just to clarify, we don't have an accommodation denial in front of us,
No, Your Honor.
right? So we didn't get to the point of what the accommodations would be for this exam because it was denied before we got there.
Exactly.
Do I have that correct?
Yes.
Okay. And I have to say, I mean, I find a lot of logic in your argument that you should get 6 accommodated attempts to take the exam. But I guess the question is, why does that render the decision arbitrary, the contrary decision arbitrary?
Because she didn't get 6 accommodated attempts. That's the problem is that she made this argument. So she was denied in May of 2024. And then she made this argument in her request for review and said, hey, I've been denied 6 times. I've denied accommodation 6 times. And this is only my 5th
If I could
attempt.
interrupt just on that point. The first 6 she was not accommodated,
Yes.
but was it a couple of those where she did not request an accommodation?
Yes. So of the 6, 4 were denied accommodations and 2 she did not request.
And should that factor, and I apologize.
That's okay.
Justice Pierce, and maybe in the context of responding to Justice Pierce, you could explain why that should not factor into the question of good cause.
Right. The two exams that she didn't request accommodations for were the first 2 exams she took in Missouri. And Your Honor, when she requested accommodations for that 3rd exam in Missouri, she was denied. So the record shows that had she requested accommodations for those first 2 exams in Missouri, they likely would have been denied anyway. So it shouldn't count against her. And then back to Justice Pierce's question, I am losing the train. Oh, here we go. So in May of 2023 or 2024, she argued in the request for review, she said, hey, she made this point that I've only had 5 accommodated attempts. And the bar in its June 2024 order did not address that argument whatsoever. It just said, nope, we affirm our prior decision. And so it gave no reasoning. It didn't address her argument. This court shouldn't defer to the bar at all in this because the court gave no findings and no conclusions for denying her request for review. And moreover, this doesn't necessarily have to be an arbitrary unfairness review. This court can exercise its own independent judgment because the bar is the arm of the court. And this court has said multiple times that it's in this case, In re Thorne, a 1981 Utah Supreme Court case, that it recognizes that the bar is not in the same status as a government or administrative agencies. And then in another case, In re Knowlton, which is a Utah 1990 case, it says the Utah Supreme Court reserves the right to draw inferences from basic facts, which may differ from the inferences drawn by the board. So we're just in a different situation than we would be under a typical administrative review. This court can exercise its own independent judgment. It has done so.
If I could interrupt on that. So is our discretion cabined in any sense?
No.
So no no standard guides our decision-making in this respect.
Well, the standard is for, good cause, right? That needs to be a fact-dependent thing, but there is no standard that I am aware of when it comes to reviewing these bar decisions. The court can exercise its own independent judgment, but generally it defers to the bar, and when it reviews the bar's decisions, it oftentimes reviews them under an unfairness or arbitrary standard.
So we would, in order to go your direction, we need to find that this decision was unfair and arbitrary, or could we just ignore the decision, as you've also suggested, and decide the case in the first instance?
Yes, you can do either route. You can either decide the case in the first instance or decide that the bar's decision was unfair. Like I said, this court has exercised its own independent judgment, but I've only found it in the case of attorney discipline cases when it's determining the sanction that should be appropriate.
Yeah, I think it's very interesting, and I think part of it might be the way that this standard came into our case law. Thorne was somebody asking us to regrade their bar exam.
Yes.
Right? And so we borrowed language from the rule that talked about when we would regrade a bar exam, and that's where we got the unfair, unreasonable, and arbitrary. And over time, it seems like we've imported that into all of our admissions decisions, and have that be the standard that governs our admissions decisions. But it does seem like that is the standard we've applied to admissions decisions. So
Yeah.
Can we truly exercise independent judgment the way we do in other cases without overturning Thorne?
No, because I believe that Thorne, and I can double check, but we have a long history of this court, well, in Thorne and in Knowlton, allowing the court to exercise its own independent judgment. It says the court, the cases are pretty clear that this court can do its own thing. The five of you are in charge of the bar. You get to decide who takes the bar. And generally you defer to the bar commissioners because it just makes your lives a lot easier. But you don't have to. And so I think you can exercise your own independent discretion if you choose to.
Can you point to me the case where we have exercised our independent discretion, or we've said we've done that in the admissions context?
Not in the admissions context. I could only find it in the attorney discipline context.
Yeah.
Notably, I'll say one case. There was one case from 1983, in re petition of Randolph Singh. And in that case, the individual took the bar. He scored, I believe to pass the bar you had to score 60. He scored a 59. And he said that there were individuals who scored that same range that were admitted to the bar. And in that case, this court said, well, we're really concerned. In this case, it was arbitrary. We're really concerned that if there are individuals who are being admitted to the bar who have a 59 and this individual wasn't, then we've got some discrimination going on. And it remanded for some additional fact-finding. I will note that I have found one case on point. It's not in the briefs. It's a Delaware case from 1980. It's in Ray Fisher, 425 A2D 601. And in that case, the bar examinee, there was a limit of taking 3 exams, and he failed his 3rd exam by 1 point. And so he asked for a finding of good cause that he could take the bar a 4th time. The Delaware Supreme Court said, good cause has been shown here. Why? Because this examinee had graduated from an ABA accredited law school. This examinee had clerked at several firms while he was attempting to take the bar. And they thought that because he was just so close to passing the bar, that was good cause sufficient to allow him to take the bar again. So we do have this situation showing up once. And then there was one more, and I'll just mention, Justice Durant, did you have something you wanted to say?
Obviously, good cause is a fuzzy concept, and it's, I guess, hard to add additional definition to what constitutes good cause. Is the best way to know what good cause may constitute to simply look at appellate decisions and examine the iterative process, and much as we do with search and seizure law, that becomes good cause. Look into the facts of the individual cases. Is that accurate, or is there some further way we could establish contours to what constitutes good cause, or inform that analysis in some respect?
Right.
The bottom line is it's such a touchy-feely concept, maybe unavoidably so. But your client's very sympathetic.
Yeah. I think it's unavoidably touchy-feely, Your Honor. So in 2004, in readoption of MA, this court reversed a district court that tried to put additional definitions onto good cause that weren't in the statute. So I think that this court has intentionally said it's supposed to be fuzzy. It's supposed to be fact-intensive. It's supposed to be specific to each individual situation. That makes things pretty uncomfortable. But like we've argued here, it also does give the bar commissions and this court some leeway to grant cases where it finds meritorious.
Yeah, it's a kind of you know it when you see it type.
I was going to say it's like pornography.
Deal.
You know it when you see it. Yeah.
But I am trying to puzzle through your answer that we could either decide independently or we could opt to determine whether the bar was unfair and arbitrary in its decision, because those are two very different things.
Yes.
And I guess your suggestion is that that's basically our election.
Yes, that is your election. But like we argued before, Your Honor, when Ms. Long made this same argument in the request for review, the bar commissioners did not address it whatsoever. They didn't address it.
Was that in the request to reconsider, essentially?
Yes.
Was the argument made in her original request?
No, it was not made in her original request. In her original request, she had argued that because there were multiple, because she had been granted accommodations before, she should be granted accommodations again, that she should receive a different accommodation this third time, and that Rule 14.711 didn't apply to her because it came into effect after she had graduated law school. So the arguments in the request for review were different than the arguments that were made originally.
So it seems like on the second attempt here in Utah, the accommodation, it had worked the first time, but it just didn't work the second time.
Yes.
With the handwriting. And so I'm just wondering what, if she were given an accommodation a third time, what would that look like? And I know that we don't have a particular request that was denied, but is there something that could address this in a better way that that exists?
Yes, so when she asked to take the bar again for her in the July 2024 exam, she asked to type instead of to handwrite, because that would be less problematic for her hand. And she'd practiced typing, and so she was hoping that by taking away the handwriting, which handwriting is accommodation and typing is not. Typing is how the bar is done. She was asking to actually take away the handwriting accommodation and just type the exam, believing that that would cause less stress on her hand, which would then allow her to not experience the pain she did in 2024 and hopefully pass the exam.
And is the difference between taking the bar examination, whether it's typing or handwriting, and doing that in daily life, is the difference just the length of the bar exam?
I think it's the length of the bar exam. I think also, right, I mean, Ms. Long, and I don't know if I'm exactly answering your question very well, but Ms. Long, when she went to law school, everything was handwritten. Like up until 2010, 2011, 2012, you could opt to take the bar either handwriting or typing. So she went through her entire undergraduate and law school education where typing wasn't necessarily a thing. It was all handwriting. But handwriting has been too hard on her hand. I don't believe she does a lot of typing or handwriting in her normal life. We've got a lot of talk to text now and other things that can assist those who don't type or write very well by hand. And so the typing would take practice, and the handwriting also takes a lot of practice for her. In fact, she practiced handwriting long periods of time before taking the February 2024 exam, hoping that that would kind of build up the muscle, but it ended up causing some harm instead.
Is talk to text an option for an accommodation that's ever been used?
That's an excellent question. I do not know.
And
That
I'm
would be
not
something
sure if she
definitely-
would want that, but I'm just wondering, because it doesn't seem like either is really quite getting at the physical problem that she's having taking this very long test that takes 2 days.
Yes, and for her, I mean, to the bar's credit, the bar gave her 4 days to take the test. So it gave her double time. So she handwrote the essays on Tuesday, and she handwrote the MPT on Friday, and then did the multiple choice on Tuesday and Wednesday. So it's a long week. But yes, I think if talk to text were an option, that would be a fantastic option.
But just to follow up on something you said, to be able to type the exam would not require an accommodation.
That would not require an accommodation.
So that's not something she has to request to be granted by the bar.
No, well, I mean, she wasn't able to get that point, but right, but in her request to take in her explanation for why she should take the bar again, she said, I would like to type it, instead I just want double time, a separate room, and breaks.
I don't mean to belabor this point, but in my mind, this case likely turns on the standard of review, because these are very compelling circumstances. And if I were deciding this in the first instance, I would be very sympathetic to your client. And I also realize that we have the constitutional authority to regulate the practice of law, and we've delegated that to the bar. So presumably we could do what you're saying and just decide it in the first instance. But what I'm getting hung up on is the fact that we, through our rules, this isn't a situation like a lot of our rules where we just say, here's the rule, the bar can't waive it, you have to come to us to get a waiver. We've actually given discretion to the admissions committee. And where we've done that, what kind of policy would that create if we were just going to review those decisions de novo? And can you help me work through why that would be appropriate when we have created a rule that gives them discretion in this area?
When the rules or the statutes give discretions to any body that's deciding something, I think that the reviewing court needs to give that body discretion if that body actually makes a decision with findings and conclusions and reasoning. In this case, we don't have any of that. When Ms. Long made the argument she's making today, which is, I have these 2 disabilities and I wasn't accommodated 6 times and I should be accommodated 6 times. Please let me be accommodated 6 times. And I got really close when I had this most recent accommodation. The bar commissioners didn't respond to that argument at all. They didn't give any reasoning. They didn't make any findings. They didn't give any conclusions. Instead, they just referred to their prior denial, which hadn't raised this argument at all.
Okay, so the arbitrariness comes in your mind in that they didn't address this argument.
They didn't, let me just see. I believe you have to show, so this is what the court has said. This court should not disturb what the commissioner has done unless the petitioner clearly demonstrates that he has been treated in an unfair, unreasonable, or arbitrary manner.
Okay.
So she doesn't need to show arbitrariness and unfairness. And I think we're here, and it's unfairness, and it's unreasonable.
What impact does it have that this argument was not raised in the original request?
It should have no impact because she did a request for review under the rules, which is permitted, and that was seen by the full panel. I believe the letter itself says that the admissions committee reviewed her request, and so it should have no bearing because she raised this argument.
There's no preservation type issue. I mean, if someone made a motion before the district court, for example, and the district court ruled on it, and then they asked for reconsideration on an argument that hadn't originally been raised, that would be a problem, right?
Yes, most of the time it's a problem.
So, but it's not a problem here, and why is that?
Well, this is a very limited record. The same group of people are reviewing this over and over again. And the rules do allow, a motion for reconsideration doesn't exist in the rules, right? It's just something that people make up. Whereas this request for review is allowed for and expressly required in the rules if you'd like to come up to appeal. But given the fact that it's something that's specifically allowed for, I believe that she can make arguments in a request for review that she didn't make in the initial request to take the bar.
Do our rules actually contemplate that? Does it say in a request for review that that the petitioner can present additional evidence or raise additional reasons?
Right, so the request for review rule is 14715A, and I do not believe that it requires any type of preservation.
Okay.
So.
But doesn't that implicit, I mean, you're asking them to review a decision they've already made. So isn't it implied that you're asking them to reconsider what they've already done, not make up new arguments?
No, I think that if the admissions committee has made a mistake in what it has argued, that it's completely proper to then.
But if
bring
it's a
up different
mistake
things.
because of what was presented to them, I mean, they can't make a mistake on something they haven't heard before, right?
There's nothing in the rules that indicates that you have to, quote unquote, preserve something in the admissions committee before you can do the request for review.
Okay, let me ask you about your argument about the findings. Usually if parties come up here on appeal and argue about the body below making insufficient findings, we don't allow that unless they asked the body below to make some findings. Did she ever ask the bar to supplement their decision or to say something about these additional arguments?
No, and I don't believe that's allowed in the rules, Your Honor. 14.715 just allows her to file a request for review for the bar to make a decision, and then I believe right after that, then we've got the appeal to this court.
But as you've noted, I mean, we don't have motions to reconsider in the district court either. But if a party doesn't alert the body to the fact that they think the findings are insufficient, our case law does require that they ask before they come up and complain about that. Isn't that fair?
Yes, that is fair. That is
Okay.
fair. But she clearly made this argument in a very short memorandum to the admissions committee. The admissions committee knew what she was arguing, and rather than addressing the exact arguments, they just affirmed based on their prior decision.
Okay, can I also ask you, you don't want us to hold the bar attempts against her where she asked for accommodations and those accommodations were denied.
Right.
But part of the problem I have with that is the first 3 in Utah, I don't know what she asked for and I don't know why they were denied. So for example, if the bar had said, provide us some documentation from your doctor, and she just had failed to do so, I don't know that we should not hold that against her. Do you know what I'm saying?
That's right. We do, because this is a 20-year-old case, we do not have records from when from her admissions decisions, her accommodations request back in 2004 and 2005.
And she didn't put into the record what she had asked for and what she was told. Is that fair?
Yes, all we know, we do have her affidavit, her declaration that says that she asked for accommodations and then she said she was denied.
Okay.
So,
One last question. What do you think the purpose is behind the 6-attempt rule?
that's a great question. About 2/3 of the state don't have a 6-attempt rule and just allow unlimited attempts. I think that the bar believes that there's after a certain amount of attempts, maybe it's fruitless to continue to try and pass the bar. Perhaps there's some indication of competence, right, if we are allowing unlimited attempts at the bar.
And just to clarify, that would be our determination because there are rules that the bar's applying.
Yes, Your Honor. And I will say the record does show in 2000 that there was an ADHD report done by a Dr. Wyckoff. And that was the report that was given to the LSAT, right? And it shows up all throughout the record. I believe it starts on page 279. But presumably that would have been the same document that would have shown up in her a request to receive accommodations for the Utah bar. This report has been around for a long time and has been showing up in all of her accommodation requests that we have on the record. Your Honor.
But she could have put that into the record, right?
Yes. We
Okay.
have that in
I'm just struggling a little bit with these early requests that we just don't have any indication of what was asked for and what was the reason for the denial.
Right. Yeah, that is a whole in the record, Your Honor.
Okay.
I guess one thing that concerns me the most on behalf of your client is that the second accommodation this time didn't work. And so I'm wondering if that was raised to the bar, that you said, well, you've said that you informed the bar that she had cramping and swelling in her hand and pain. Was that made clear to the bar in this request that was denied, that the February 2024 accommodation had actually not worked,
Yes.
and so she needed another attempt?
Yes, so
for
that was
reason.
made, so that was before I came on and we did the request for review. So she made that clear to the bar when she was applying to take the July 2024 exam, that that her hand had cramped, and that was something that was a surprise to her, and that it caused extreme pain, and that she was going to a doctor and things to get it taken care of.
And what was the response to that?
Well, I mean, the response we have is this May 23, 2024 letter, which is on record page 248. And this is what I said: the committee does not find the previous grants of your petitions could cause to grant this petition, nor does the argument that allowing you to take the exam would further the goal of ensuring Utah citizens. And then they said, although the committee is sympathetic, it does not find that establishing the need for different accommodation is sufficient good cause. So that's what the bar said.
Thank you, Ms. Adams.
Thank you.
Ms. Lee? If I could start you out with a question.
Absolutely.
So the bar reads the rule as 6 bar examinations, not 6 accommodated examinations, right? How many times did the bar allow Ms. Long to take the bar after she had reached the 6 exam limit?
Twice.
Okay, so twice, and then after the second, they decided that's enough.
Correct.
Okay, now, I'm wondering why that is not arbitrary. I mean, are they just saying, well, you know, we just kind of feel like that's enough? If they allowed her to, already allowed her to exceed the limit, why wasn't it arbitrary to just kind of draw some line? Or maybe, what was the reasoning behind drawing that line? Why was it not arbitrary?
Sure, and that's a great question. So when they first granted permission in 2023 for her to take the exam, a long period of time had passed between her last bar exam attempt and this attempt in 2023. And they determined that given the change in the exam, given that long period of time, that they would allow her another attempt. In her initial request for permission, she asked that the committee grant her up to 5 additional times beyond that one. The committee indicated in their decision that they are only granting her permission to take the one, and that it's premature to discuss the others. On the second request, the committee made clear that while they were granting it because of her reasoning that upon waiting for the decision in 2023, she was not sure she was going to be taking it in July again, so she wanted additional time to study. She didn't study enough. They determined that that was also good cause. But they indicated in that second determination that they were hesitant to grant that one. And so she was on notice that if she asked again, the committee was already hesitant to continue this. And so I think that establishes the non-arbitrariness of it. Those first 2 attempts had some solid reasoning to it. This third attempt, given all of the facts, given the fact that they had already granted her twice permission to take it again, and she was on notice, they determined that that third time just did not establish that good cause.
Can I ask you about that? Is that in the letter where they denied it? The reasoning you have just articulated?
Can you be clear about which letter you're referring to? Because there are a few letters.
Oh, okay, so let's do the 2 for the most recent request,
Yes.
right? So in the initial letter, right, did they articulate the reasons you've just articulated for why there was not good cause?
So in the admissions committee denial of her actual petition for permission, they did outline their reasons for why there was not good cause.
And I think they said the previous grants were not good
Yes.
cause, right? The fact that they'd been granted before. I think it said that allowing her to take the exam, furthering the goal of ensuring access to competent and ethical attorneys, that was not good cause. And then it said establishing the need for different accommodations is not sufficient good cause.
Correct.
But I don't recall anything that speaks to what you were just saying in response to the chief in the letter. That, hey, this was all spelled out to you when you made your initial request, and therefore you were on notice, and so we don't find good cause. Did I miss that in the letter, or?
No, you did not miss it. But those reasons that I articulated just now, I backtrack on that. Those were not articulated in the letter.
Can you tell me if
Specifically.
they were in the, because what you were just saying about granting the February 2024 makes sense to me, because I know she was asking to take the 2024, and then she had to take it so close together. but was that spelled out in the second grant? That the reason that they were granting that was because she hadn't had perhaps sufficient time to prepare for the July 2023 exam?
The grants did not outline
Why?
the reasonings. The
And we
grants
don't
were-
have that in the record at all? I
The
mean,
reasoning?
there's no minutes or anything that would show what the reasoning was?
No, the minutes aren't included in the record.
Okay.
Can I ask, as we think about good cause, one way to assess good cause perhaps is by what's the purpose of the rule that you're seeking some relief from? And on page 10 of the admission committee's brief, it suggests that the reason that the limitation exists is because we have some concern that if you take more than 6 times to pass the bar, you might not be a competent attorney. But there's no citation for that. And so why does the bar believe that that is the reasoning underlying that rule? And the reason I'm skeptical is because, as Ms. Adams points out, it seems like we're in the minority of states that imposes this requirement. So why does the bar think that's the reason this rule exists?
Certainly, and I'm glad you asked that question because I think the history of this rule is important and quite relevant to this discussion. So the idea of bar exam retakes, and this might be more than you're asking, but again, I think it's relevant. So the rule has been around for quite some time.
Since 2003?
Well, the rule about 6 attempts has been around for 2003. Prior to that, in the 1970s, it was 2 times, and then you have to wait a year, and then they can ask permission. In 1983, I believe it was, there was no limit. The rule changed, there was no limit. And then in 2003, the rule came back, didn't come back, the rule was changed to add 6 examinations as the limit. At that time, the argument was twofold. First, the National Conference of Bar Examiners had a recommended standards for bar examiners. And one of those recommended standards was that someone should only be able to take the exam 3 times, and then after that they would have to prove that the reason for the failure had been remedied. So that, coupled with the bar's belief at that point, based on some psychometrician and other discussions, was that the more times that someone takes the exam, the less likely that passage of the exam would be based on minimum competence. And it would be more likely that they're simply understanding how to take the exam. So in the petition to this court for that rule change in 2003, that was the basis. So the 6 examination attempts was approved in 2003, and that has remained. The numbering of the rule, the placage of the rule in our rules in the canon has changed since then. The most recent change in 2020 was to specifically address the UBE, and that a passing score would be equivalent to the passing score in Utah. Does that answer your question?
Yes, is the petition for the rule change in 2003, is that in the record before
That
us?
is not in the record.
Okay. Kind of to go back and follow up on something the chief asked, why would we not say, given what's in the record in front of us, right, what we have, since we don't have the basis for the grants before, of the grants of the additional requests to take it the 2 times with accommodation, since we don't have that reasoning in the record before us, how could we conclude that it wasn't arbitrary to deny it this time if there was good cause the prior time, based on what's in the record before us?
I think the bar's position on that is that there is no requirement in the rules to outline exactly why they are granting, simply because good cause is a factual determination, and within their deliberation, that admissions committee determined that there was good cause on those 2 occasions. On the 3rd time, the denial from the admissions committee outlined their reasoning for why there was not good cause to grant it a 3rd time. So I think it's important for this court to remember that the admissions committee, as was pointed out, has been given discretion specifically for this determination. It shows the court's trust in the admissions committee to be able to determine on a factual basis whether or not there was good cause to grant or deny one of these petitions for permission. So,
No, go ahead.
no, just to sum that up, I think the fact that they did consider it twice and they told her that they were hesitant to grant it a third time.
But that's not in the record.
That's not in the record. But the hesitation to do so is outlined in one of the letters. Makes this not arbitrary. And I think the fact that the admissions committee they're not asked to make a subjective decision here. There has to be some objectivity and some trust that they're making an objective decision. To put into this rule a qualifier that someone can ask for more accommodation or less accommodation, or the accommodations didn't work this time or that time, creates an arbitrary standard for them to follow.
Okay, if I go. So, obviously, Ms. Long isn't asking to be admitted to the bar. She wants a chance to pass the bar. And we usually find that the fact that someone can pass the bar is sufficient for our purposes to allow admission. The public's protected. There's an understanding of ethics. But you're suggesting, well, maybe that's not the case if she'd taken multiple bars, because the NCBE has suggested she simply acquired the ability to take the exam. And I have to really question that NCBE conclusion, because I think many well-prepared students before ever taking the bar exam have taken who knows how many practice tests. I mean, it seems to me if we're going to rely on the bar exam as the measure, we shouldn't be questioning its efficacy in this case. So I just wonder if your concern, and it's a legitimate one, about ensuring competent lawyers and ensuring ethical lawyers, that concern is not met if someone passes the bar having taken it multiple times. Do you want to defend that position a little bit more?
I do, but I want to be clear that I'm not defending that position. I'm simply trying to explain the premise for that rule. I think you make a really good point. And it's important for this court to note that over time, many of the states who had limits at one time no longer have limits. So the fact that in 2003, the bar's position and the court's position at that time was we need this 6 attempt limit because of these reasons, as I explained, does not mean that that cannot be viewed again. It's been 22 years since that basis, and it has not been changed. So that's the rule as it stands, and that's the premise on which the rule was created.
And just to be clear,
Yeah.
that's not the bar's policy choice that it's made. That's this court's policy choice that the court made in 2003.
That's correct, yeah. And as has been stated, we can't waive that rule. And the admissions committee is operating within that standard given to them in Rule 14711.
So in Ms. Long's attempt in February 2024, when her hand cramped and she had pain, what's the reasoning for not allowing her to try again when it seemed like that time, for whatever reason, the accommodation just didn't work? And it's a physical problem with, physically answering the questions rather than an indication of not knowing the answers to the question.
Sure.
What is the bar's reasoning behind that?
The reasoning there, and again, this is not in the record, but the reasoning is twofold. One, I think there's an overlying idea that the bar exam is an uncomfortable exam regardless for anybody that takes it. And so starting down a road albeit Ms. Long's facts are different. Starting down a road where, oh, I was uncomfortable, something started to hurt, I got sick, something like that during the bar exam, to simply open it up as that is a basis to be able to take it again, I think creates a standard that really closely needs to be looked at. But the other reasoning is the one that we have hopefully outlined in the brief, that test accommodations are a unique part of this bar exam application process. We have a test accommodations committee made up of professionals, attorneys who look at these requests under the ADA and make determinations on whether or not these requests are warranted. There's a concern that it would undermine the ability of the test accommodations committee to do their work if someone can simply come again and again saying, oh, that denial was not correct, that denial was not correct, without taking measures at that time of the denial of the accommodation request to remedy it, simply because it didn't work. And so when the admissions committee, and I'm assuming you are talking about the review and not the initial petition. Does it matter? It might not matter. When they were looking at those facts, that was part of their thinking, is where does this lead if we are to start making a decision on whether or not an accommodations denial was correct without more about that denial. And Ms. Long has actually taken it, if we're looking at the 5 times that she took it with accommodations that she requested, plus the 2 times that she did not request accommodations, but she knew she could have, we're looking at 7 attempts. So she's already beyond the threshold of the 6 allowed attempts here in situations where she knew or should have known that she could have gotten accommodations. I think that's an important point that the bar wants to make, is that the decision here implicates the test accommodation process in addition to the admissions committee's discretion in these cases. And it allows for the admissions process to go forward objectively and fairly with notice to the applicants of what to expect and what they need to provide to us in order to get what they need under the accommodation. The bar is not arguing in no dispute that those who warrant accommodation should get them. What we are concerned about is where the line is on how many times a particular accommodated individual can take the bar exam based on ever-changing accommodations.
So I have a question.
I wonder if one thing that's slightly different here is we may be operating in 2023, 2024, 2025 in a different world in terms of understanding accommodations than in 2004 to 2007. So it's not necessarily 6 tries in our current mindset, but kind of spread over time that may be slightly different, but I take your point.
Can I ask how those 2 things work together, the admissions committee and the accommodations committee? Because I assume that the admissions committee has to approve you taking it more than 6 times before the accommodations committee looks at the potential accommodations. Is that right?
That is correct. I want to explain that slightly. In the last few years, the process has changed. We've recently gone online to applications, and those who are seeking to take the exam more than 6 times are precluded from actually applying. So they can't apply or make a request until they have petitioned the admissions committee. A few years ago, that was not the case, and someone could apply and ask for the accommodations prior to sending the petition to the admissions committee.
Because the application in 2023, if I'm remembering this correctly, it looked like she had already obtained the accommodations, and then the character and fitness committee realized that she'd taken the bar more than 6 times. Is that right?
That's correct.
Okay, so that was just changed. Now, in this case, as Justice Pierce pointed out, typing the exam isn't actually an accommodation, that's just standard.
That's correct.
So the only, if she was going to put on any evidence, like, of these other things that Ms. Adams has mentioned today, like carpal tunnel and these different changes to the functionality of her hand, that would have come in the petition to take the bar exam again, right? I mean, that would only be relevant to that decision, since there would not have to be any accommodation for typing the exam. Is that right? I'm just trying to figure out if she was going to present evidence of what the concern was with the last time she took the bar, it would be to the admissions committee. Is that right, in this instance?
Yes.
And there wasn't any information about, it only said that her hand was cramping and swelling, right? There wasn't any additional documentation or explanation of why that occurred or why that was different than prior attempts?
As far as my recollection of the record goes, there was not.
Okay, and one other record question. So you were talking about the last grant may have been based in part on the fact that she hadn't gotten a lot of notice before taking the exam in July 2023. And I know that reasoning wasn't spelled out in the admissions committee grant, but was that the basis for her petition?
That was.
So can we look to, assuming, if the admissions committee grants or denies something, and we're trying to figure out why, is it appropriate for us to look to the petition to see what reasons were presented?
Yes, if I'm understanding, I just want to make sure I'm understanding your question. So when they get a petition for permission to take this exam, you're asking if they can look to that petition only or to previous petitions as well?
I suppose what I'm saying is, for example, when we're trying to figure out why the admissions committee granted the second request, because I think that the chief made an excellent point earlier that why isn't this arbitrary where they granted that one but didn't grant this one? If we're trying to figure out why they granted that one and what was different between these two petitions, can we look to her petition to say, okay, the reason she was giving to justify that attempt in February 2024 was because of the lack of notice between the time she was granted permission and the July 2023 exam?
I believe so. I don't think there's anything that precludes that.
Can I just make sure that I understand how Rule 14.715 works? So is the body that hears the request for review the same body that made the initial decision?
In this particular, when we're dealing with Rule 14.711F, yes.
Okay. So for this type of request, it's the entire admissions committee both times?
That's correct.
Okay. And then as I look at 715D and it talks about the review process, the rule says it's a closed proceeding limited to the consideration of the record, the applicant's memorandum, and the bar's responsive memorandum. Has the bar ever taken the position that review is limited to the arguments that were raised below, that in the memorandum in front of this same body again for review?
No.
Okay.
No. And if I may point out in response to a question that I think Justice Pullman brought up in relation to this, if you look at 14.715C about the standard of review for a request of review, the decision, whether based on testimony or documentary evidence, shall not be set aside unless clearly erroneous. So that review is looking at the record and the memorandums to determine whether or not there was error in that decision, and not necessarily a completely de novo review.
And so, sorry, just to follow up on where I thought perhaps Justice Pierce's question was going, do you read that as allowing a petitioner to raise new arguments or present new evidence in a review hearing?
I think plain language of the rule implies that it is not a de novo, and so that new arguments cannot be raised. Again, that has never been exercised.
When you say never been exercised, meaning you've allowed parties to raise additional arguments, not necessarily additional evidence?
To my knowledge, a request for review has not been denied because new evidence has been raised.
Oh, so you are even allowing new evidence to be raised on review?
Yes.
Okay. I mean, which comports with my understanding that
Yeah.
this is a very informal
It is.
proceeding, right? This isn't something we're following the strictures of the Utah Administrative Procedures Act.
Right.
These are volunteers, and we're doing this very, what's the right word? Leniently.
Informally, yes.
Yeah, okay.
It is, yeah. So the bar asks that the court affirm the admissions committee's decision.
Thank you, Ms. Lee. Ms. Adams?
Thank you. 2 points, Your Honor. Justice Hagan's question about the May 2024 petition. It's on page 219 of the record, and in that petition, Ms. Long says that her hand has significant pain, that she has to type. She says that her only hand is deteriorating with use, and she mentions that she had surgery on that hand and it is fragile. So all of that information was in front of the admissions committee when she asked to take the bar in July of 2024.
Tell me that record site one more time, please.
219.
Thank you.
And then finally, this court, when we're looking at good cause, there is an Alabama case from 1975 that talks about good cause that might be useful when this court is looking at whether good cause has been shown. In that case, Alabama had a 3-test limit, and the Alabama Supreme Court said that when deciding whether there's good cause to give somebody a chance to go to a 4th exam, they should look at whether circumstances existed at the last 3 examinations as to make it unlikely that the applicants had been fairly tested as to his competency to practice law. And I think that speaks to Ms. Long's experience here. When she took the bar 6 times 20 years ago without accommodations, and as Justice Peterson mentioned, I think our approach towards disabilities and accommodations was significantly different 20 years ago. She wasn't fairly tested as to her knowledge of the law. And now that she is able to receive accommodations, she's gotten so very close. And hopefully, she asks that she be allowed a 6th accommodated attempt so that will fairly test her ability and knowledge of the law. Unless this court has any other questions. Thank you.
Thank you, Ms. Adams. Ms. Lee, we appreciate the briefing in this case, as well as the oral argument, and we will take it under advisement